everyone, welcome to MJTLaw and the Lawcast. This is Mr. D. Santana, Chris D. Santana, and my name's Melanie Thorley, and we're both solicitors at MJTLaw.
And we're back for another week here at the Lawcast. And I thought I'd kick us off with a couple of cases this week. We know that, coming out of, we've got a new federal
Labor government instead of coalition.
We've just come off the back of a Jobs Summit. We know that industrial relations, whether good or bad, is going to be more in the headlines.
This is right, and we've been talking about changes for some time now. We're getting more into the quick and dirty of it. I suppose for everyone out there, I think it's probably important for us to outline that employment and industrial relations are slightly different, although for the wider world it probably all seems like the same. Employment's more in relation to individuals, and I think in industrial relations is a little bit more collective. Yeah, we can make some distinctions there, I think.
And the couple of cases I have here are first going to be some very familiar names involved, but also I'm going to call them the industrial relations gone wrong. Is this a little bit like Chris's commission Crazies? Yes, just on an industrial relations area.
I'm interested to see what happens.
So the first case is involving some very familiar names, as I said. It's the CFMEU against... it's actually the ACCC against the CFMEU and Hutchinson Proprietary Limited. So,
I think they've renamed themselves from Hutchins to Hutches, right? Or something.
Well, their company name is still the same.
Yes, of course, sorry. The rebranding of Hutchins.
So this particular case is involving something that, for people in the know, we know happens quite often, but is quite unlawful. So what happened on this particular case was... I'm going to just got stuck calling them Hutchies.
Okay, Hutchies.
So Hutchies, they engage a plumbing subcontractor to work on their site.
I think I know.
It's quite a big contract.
I think I know where this is going.
And it subsequently comes to light after signing that agreement, but before works begin, that this subcontractor doesn't have an enterprise agreement, and specifically an enterprise agreement negotiated with the CFMEU, who there doesn't seem to be any challenge that they had. They were allowed to be involved in that particular site, and the CFMEU gets on the phone with Hutchies and says that they threatened industrial action and that they were, quote, going to make life very tough for Hutchies on this particular site if they allowed this subcontractor to, company to work on the site.
Yeah. So none of this is controversial. It's all in evidence.
It's all in evidence,
and it's all public.
Yeah, there probably would have been emails and things like that, which
probably a fair amount of evidence.
And it's interesting that it's the claim is brought against the two of them by the ACCC on the basis that it's not only is it unlawful in a fair work act, it's anti-competitive.
Yes.
Because you are essentially forcing...
But hang on, I don't think you said the rest of it. So we've got this plumber who's joined the troops by contract, doesn't have a CFMEU... we're going to say enterprise agreement, but that's not really what it is. It's the CFMEU weren't involved in any kind of bargaining with this plumber.
Yeah.
So the CFMEU has gone to Hutchies and has said, there's going to be trouble, guys. And then
Hutchies not wanting any type of issues, and remembering that these particular parties, not only do they have to keep a good relationship between the two of them on that site, but they would deal with each other on 50 sites, 60 sites.
For those of you who are not in the construction industry, you probably have seen Hutches, flags, material, building sites all over the place here in Australia. I'm not sure how broad they are overseas, but we're talking about two massive organisations. There's this huge union, and it's a huge conglomerated union, and we've talked about them trying to get out before. And we've got this huge construction company, which is almost we've in Australia, it's probably if we've got a big 3 or big 4, it's going to be part of those guys. So we've got 2 big companies chatting to each other about whether or not they should allow this plumbing company.
And
part of a ticket to play.
And the court found that there was a coercion there, and because of that, the CFME, the Hutchies cancelled that contract, and subsequently got a different contractor.
That's right. They got rid of the plumbers. Got
someone else who did have an enterprise agreement, and they were slammed. Both of them.
They were slammed.
Absolutely slammed.
I really like this case.
Really big penalties.
I really like this case because what it does is it shows that anti-competitive behaviour can still be prosecuted.
Absolutely.
And there are true and real possibilities. No matter how big you are, you can still get. Look, I'm not sure that the figures are a punch in the face or a slap on the wrist. I'm not.
It's hard to tell.
Yeah, I'm not involved. This is all after profits money, and I'm not sure how much it's going to hurt them in reality. But yeah, this is a really interesting case.
So they both got very, very close to maximum penalties.
Yes, they did. In fact, wasn't the CCC asking for maximum penalties in the case itself?
Yeah. So the CFMEU got. They did in fact get a maximum penalty, and the reason being there was a case earlier this year which basically said if you've been bad in the past, if you have a history of breaches, then a maximum penalty can apply irrespective of how seriously.
I'm kind of laughing because wasn't that a CFMEU case as well?
It was indeed.
So the CFMEU have been slammed twice this year.
Yes.
From the courts in terms of penalties for their bad behaviour.
And if you do want to have a bit of an idea about how much of a slap on the wrist this was, so they were fined $750,000. And Hutchies was $600,000. And I'm not too sure about Hutchies, but for the CFMEU, they noted that the particular branch that this was attached to, being the
right, because they've got these
branch,
sub-areas,
has net assets of about $2.4 million. So a $750,000
makes about 40%.
It's not a small it's not a small fine. But what I found really interesting about this case...
Net assets of $2.5 million.
For that branch.
What are people paying in subscribing fees? Because if they're able to... I'm just saying, if they're able to litigate to this extent, as often as they do, I feel like we're undercharging. That's all.
And now, the CFMEU's involvement in this is... we know this goes on. We know this happens on a lot of sites.
This has just got to be a conversation that happened that is fine. This has got to be one of 100 conversations, right?
But what I really like about this case is that they went after Hutchies for it.
They did.
And
because Hutchies could have said no.
Exactly. And I'm going to quote here.
Yep.
It said, when we're thinking about specific deterrence, to turn Hutchies to do this again, to not do this again, said their conduct fell squarely within the mischief to which the act is directed, being it's capitulated to threatened industrial action to avoid personal loss or damage at the expense of third-party suppliers. The builder regarded the avoidance of industrial disruption as being more important than the cost of compliance, which goes at the very heart of why we have penalties. Because it was actually cheaper. In their mind, they knew that what they were doing was wrong. They knew exactly that it was in breach of a number of different sections of various acts, but they didn't want the fight. They didn't want the loss, and they kind of rolled over. And it sends a very good message to, I think, a lot of organisations out there that, you know what, you can't be in cahoots.
Yeah, I really like this one as well because the plumber had nothing to do with this. All they were doing was running a business, and they just happened to be free of union involvement. Involvement, or you might want to say coercion if you read this case with a different set of lenses. You know, all they were doing is running their business, getting on with it, and they just didn't have a unionised organisation. And what the CFMMEU were doing was essentially going out there, forcing people to join unions in order to be able to go on site. And this poor guy had employees. I mean, this is not one guy doing something. Yeah, this is actually quite a large organisation. It's an organisation themselves that relied on work. And now it's almost a statement out there for others who are like this plumbing company to have to get the unions involved more and more often. And this is just a subscription drive in many ways for the unions.
And we hear it, time and time again from clients who sort of say to us, do you really want an enterprise agreement? And they kind of say, not really. But we don't feel as though we have a choice.
Yeah.
And this is exactly what this case is starting to get at, which is, they do have a choice. And they should be afforded that choice, and they shouldn't feel the detrimental effect where, frankly, there is no lawful way of stopping that.
What's really sad, though, in this case is it's not the plumber who got those penalties. It would have been, the ACCC did the fight. It wouldn't have been the plumber that received the penalties on that.
Well, I'm not too sure whether there is a...
And it wasn't their argument. They didn't create this argument. So they didn't go in guns blazing and say, because they probably didn't feel empowered to be able to do that.
No. But, whether they haven't yet, or whether they have already, I dare say there is there's going to be a second case involved in this, which might be a breach of contract from that plumber against...
It's going to be easy to win.
Yeah, you just kind of start waving around this thing that said the reason you terminated the contract was because of some actually unlawful stuff.
Yeah, that's a really interesting case actually with the penalisation of hutchies. I wonder if any lessons get learnt on these, because if we say this is the second time the union's done it this year, that could be because they were both in the mix at the same time, and the other one was heard earlier than this one, and that's just how it went. Or we could say that they just didn't learn their lesson the first time round, did it the second time. So I'd be interested to see how this plays out in the future, especially with our Labor government, because Albanese is an ex-union boss. And I think there is a lot of sympathy out there for the unions with our government at the moment. So I wonder how this is going to play out in the new climate we've got as well.
In the way that it's almost kind of in complete combat with the tide.
Yeah, well, yes and no. We've got a lot of changes happening at the moment in employment. We know that the Albanese government wants to sort out enterprise agreements, and we're calling this collective bargaining. And I've used the term,
sympathetic.
Sympathetic striking is a collaborative industrial activity situation. But I wonder whether, just like with the coalition government, would change laws in order to affect changes, to affect changes that had happened in the High Court about casual workers, to stop the unions from being able to affect that change through the court system, which is what happened. It's now going to go the other way.
Isn't it?
I don't know how it's going to play out.
They might do, but isn't it ironic that, when we're thinking about penalties, and the idea of trying to, they're there to try and deter, both you doing it again, but others also doing the same. We think about employers. So you'd think that, I just suppose, isn't it ironic that the one who's really hurting out of all of that is not employers. It's not Woolworths. It's not the BHPs of the world, these really big employers in Australia. It's the big unions who are really feeling the pinch of repeated offending in a situation where, earlier this year, I'm not sure whether it was that case or the one before it. It was one contravention, and I know it was only for $66,000. It was a fairly minor contravention, I believe, by the CFMU, but they got the maximum out. And she says to me that the courts basically for the CFMU, and I think
they've lost their appetite. They've lost.
It's just gonna become a modus operandi.
They've lost their sense of humour. They want it to stop. They want these guys to be who are repeat offenders in the courts. To stop it, to cut it out.
If you breach it, it's going to be the maximum amount. You can expect that amount to be what?
Yeah.
Well, the next case though is, I thought it'd be good to kind of contrast the two situations. We've got a union and an employer who's been very naughty in that case. But this one's slightly different. Again, CFMU.
Okay.
And again, we're in constructions. We're in Sydney, though. We're in a luxury apartment construction near the Opera House. And this involves a situation where, on 3 occasions, a union-permitted licence holder. So for everyone out there, the union has permitted licence holders, and they have to go through a sort of vetting situation by the commission, and once they get this card, they can go onto sites in order to, and then in this case it was for safety concerns.
Yeah.
And
so it's like an overseer, like a regulator, but a union. Space. Yeah,
it's the formalised way of, and we hear, and everyone has these horror stories about, the union rep coming onto site. That's actually what it is, but in a formalised way. Standardised space. They make an application. They've got their ticket to do that. It goes through the process, and then they're allowed on site. Yeah. And there are some tests. Like, they're not allowed to just come onto site as a matter of course.
No.
They do need to have a reason.
Yeah.
Now, there's a bit of a story to this one because on the first occasion, this union rep comes on he tries to go on, so he gets an email about some still water that was sitting in this site. Mm-hmm. He turns up in the morning and he gets confronted at the front gate and says, no, you're not.
Yeah, you haven't gone through the proper process, dude. You can't just walk in.
Now, he then proceeds to explain and show the email, the complaint he had received from a worker on site as to what the safety concern was. And interestingly, in the case, all the safety concerns, it was later conceded all the safety concerns were actually legitimate and reasonable. Mm-hmm. But the foreman, if you want to call it that, wasn't having a bar of it.
Yeah. I don't care what you've got, dude. You're not coming on site.
And the explanation, he basically says he's not coming on site. The explanation he later gives is that he thought that the union rep was on a, quote, fishing expedition.
Okay.
He's there to dig up some dirt.
Okay.
And
reasonable belief.
The federal court didn't appreciate it at all. They said there was absolutely nothing to suggest that there was any fishing expedition to be had. And after a time, to be fair, he just gives up at the front gate. So he's only delayed by about 4 hours, and he allows the person on.
Okay.
That's the beginning. Okay. So that's at the end of May.
Right.
Middle of June. Now remember, we're June 2020. Okay. We are, what are we in COVID terms, 3 months in, roughly? And how do I say this? Everyone's a little bit heated. Everyone's a little bit scared. Everyone, especially employees, and one of their major subcontractors goes bust, and they're locked out of the site naturally. Okay. Them and all their workers, and the CFMU doesn't like this at all. They said that they were requesting for the company to not put in a new subcontractor until such time as these employees are paid their entitlements. And
how was it the fault of the head contractor to pay entitlements of the subbies?
Entirely what the company says, and says we don't care.
And I'm going to go as far as to say that most service agreements or contracting agreements say you're in charge of your own employees, dude. That's a matter for you.
Yeah, and that's exactly what happened. And they got a new contractor in. And in there starts the protest. Gosh. And this goes on for about a month in the end. Okay. Where the former employees, I should say, the current employees of the former subcontractor are out the front. They're picketing all the time. They, at one stage, refused to allow any trucks to come on. They were linking arms to stop them.
Okay.
I mean, it's not really explaining the case why they feel as though that company should be the one paying them.
I was going to say, the entitlement is off the Kazam, but sure.
When really, it's their actual
it's got nothing to do with
that
poor chap,
who they should be picketing against. Nevertheless, in order to avoid the conflict between, because what ends up happening is these protests are at the front of the site. These new employees are coming from this other company, faultless, and they're getting into a few scuffles at the front of the site.
Of course they are.
So, to avoid this, the company then allows them to use a back entrance. Unfortunately, that's a egress. So you've got an ingress problem.
Yeah. Okay.
So, I suppose a key piece of detail is during this protesting, there is also CFMEU union reps that are involved.
Yeah.
And a safety concern happens about the ingress problem, and the same union rep that was there
3 months earlier.
A month earlier, who it should be said was not involved, not knowingly involved with what was going on.
The malarkey around the protesting.
And he comes to the front gate. Pretty much the exact same situation happens. And the foreman again says, no.
Piss off, yeah.
No. And I assume there was some expletives that were never mentioned. And tells them, piss off, you're not coming in. This is all about this protest, doesn't allow it.
Yeah.
Goes away, go away. Next day, same thing happens. So there's the third breach.
Yeah.
And for everyone, they were found to have breached the Fair Work Act. You're not allowed to stop a permitted cardholder to enter a site where there is reasonable grounds. The reasonable grounds were there. But the reason I find this case interesting is it really shows what happens when reasonable people, because I think everyone involved is fairly reasonable, what happens when you're in the industrial dispute, and when this is what happens when you've got a lot of industrial kind of conflict happening all at once. You lose the wood from the trees, because in hindsight they all agreed that actually the safety concerns were legitimate, and with clarity of mind, they should have really.
I think if we're going to talk about, let's set aside the first one where the guy just says, no, I'm not letting you on site.
That's distrust. That was actually just distrust between the two.
And you can see that, based on the previous case, why that might exist.
Yeah.
But I think the problem, the blame should be laid squarely on the lap of the instigator of the protest. Because someone racked these guys up. These guys were getting in their cars, driving there every day to get up to mischief. Someone was enabling that and encouraging it. Look, obviously we can't say who that was, but you can imagine that this person who is letting this card holder on or off site is of the view that it was the union who was doing that. And the reason why all this is happening to begin with was their fault. And if they had just calmed everyone down and told them all to go home, this problem wouldn't be existing. Whether that's true or not, obviously we don't know that in the evidence. But that was probably in the mind of the chap at the time who wasn't letting him in. And to be honest, if the union had behaved better in the past, in multiple situations, there would be more goodwill there to go, oh, okay, I can accept it's probably not you guys. Yeah. Do you know what I mean?
CFMU is a very large organisation. I understand. I can separate my conflict with what's going on with this protest at the front to actually, and there were some other safety concerns as well, but basically things that should actually just really be addressed in an ordinary course.
But this is why organisations should behave better on a day-to-day basis, because the reason why this card holder was going on site was the safety concerns. If they had behaved better consistently over the past years, there wouldn't have been any question of allowing that person on site, and the safety concerns would have been dealt with more effectively and efficiently. I I mean, yes, okay, we can lay blame on lots of people, but there is a inherent distrust, and I think our previous case shows why.
Yeah, and that particular foreman in question, absolutely, there was, they were probably dealing with. There was some evidence that they've been in the thing for quite a long time. They've seen it all happen before, and they just simply lost the woods from the trees.
Yeah, you can't separate that conflict guy, from the conflict that's happening. And this guy might be straight up and down, or he might not be, but that's irrelevant to the reasons why he wasn't let on site to begin with. He hadn't expressed any distasteful activity to date. It wasn't his fault. The protests weren't happening, but he was the guy of the hour. Both of those are fascinating.
I think in many ways, without being too dramatic, I think it's a bit of a window into potentially what the coming years. So, some of the issues which might be a bit more prevalent moving forward, because you can only imagine the more time that union organisations and especially, some of the more kind of aggressive kind of employers, the more time they're going to have to be forced to spend time together, the more situations are going to get like this, where actually this was almost like a second to disaster situation.
Yeah, you can watch this. This is a slow train wreck.
Yeah.
And this slow train wreck's been going for years, probably.
Yeah. And I think it'll just be more wrecks happening a little bit more quicker in time, and there's going to be a lot more issues, I think.
And I think the courts are facilitating that in many ways by allowing these high penalties to be awarded, making it more profitable and advantageous for employers to be taking these unions to court, because they can see from their perspective a light at the end of that tunnel.
Yeah.
Interesting.
Well, that's everything that I certainly had for today, and I think that's us for the week.
It is. Thank you for watching the Lawcast, everyone. If you have anything to say on this, please put it on.
Send us something. Get in touch with us if you've been in a similar situation.
Yeah, fascinating to hear.
Well, see you next time.
See you later, guys.